Welcome to today's program titled Guidance on State and Local Paid Sick Leave and Paid Time Off Laws, Part 15, Paid Sick Leave in 2025, Legislative Updates and State-Specific Strategies. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread, and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Josh Seidman. Josh, please go ahead.
Great, thanks, Kate. Hi, everyone. Hope you're all doing well. Good afternoon. We're 2 minutes into the afternoon everywhere, so good afternoon to folks. It is great to be with you today. This is off the heels of our paid family leave laws webinar that we had yesterday afternoon. Thanks to everyone who attended that session. Today, as Kate said, is part 15 of our ongoing paid sick leave law webinar series. We are going to be jumping all over the country. We have joining me 3 of our wonderful, very skilled leave attorneys from our leaves of absence management and accommodations team, Jean Wilson, Kathy Feldman, and Renata Walker. I'm Josh Seidman. So happy to be with you all today before the holidays. So thanks everyone for joining us. Next slide, please. All right, so here is a snapshot of our agenda. We will be starting off with a very quick nationwide overview, then jumping into the latest and greatest round of amendments, many of which have happened over the last several months, right? Sort of the second half of the year. So Jean will be starting us off with Connecticut and Massachusetts. Then we'll be turning it to Kathy to talk about California and Michigan. Big changes, especially coming in Michigan the early part of next year. Renata is then going to take us through the Minnesota amendments, some of which happened earlier this year, and a major one that starts 2 weeks from today on January 1st. Renata will then also talk about the 3 new paid sick leave laws that were enacted last month as ballot initiatives. And then I'll round out the discussion with New York paid prenatal leave that comes online at the start of the year and a quick outlook into 2025. Oh, next slide, please. And one more. All right, so this slide is one that we've been using across this webinar series. It's actually a lot of fun to update it, tweak it, and see how it kind of changes from year over year, or presentation over presentation. Starting that column, total mandates. Today, there is a solid 60 total paid sick leave PTO laws in the country. Now, these laws include a variety of different types of laws. It's paid sick leave, paid sick and safe leave, paid safe time only, PTO, public health emergency leave, the 1 paid prenatal leave in New York that we'll be talking about, and the 1 straggler COVID paid leave law that is still online in New York for at least another 7, almost 8 months. So we have those laws that all bundle together to get to that total mandates. This time, 4 years ago, there were 69 total of these laws in the country. The reason for the ebbing and flowing over the last few years was because of the COVID paid leave laws that were on the books for a temporary basis, coming and going. But you also have laws that start up in the non-COVID space that might preempt or have a local law sunset in response to a state law. So that happened in Duluth, Minnesota at the beginning of this year, for example. In that second column, the federal column, we still have Executive Order 13706 online, providing paid sick leave to employees of certain federal contractors and subcontractors. Then you get to that third column, which is the one that has a lot of the updates, all the updates we'll be talking about today, and these recent big developments. We're running out of room in that column, frankly, with the amount of developments that have been happening. We've highlighted the big players, and as you'll hear from Renata, and then I'll chime in throughout today's discussion, those 3 ballot initiatives, which are highlighted in that teal font, Alaska at the top, Missouri, and then Nebraska at the bottom of that third column, the leftmost column within that third column. Those are really big deals because of the geographical expansion that they represent of this paid leave space. So we'll focus on those throughout the discussion today. And then also rounding out our municipalities. You can see the growing list there as well, over 24, a lot of cities, major cities, a number of counties. Several of these locations, like Colorado, like San Francisco, like New York, Maryland, among others, have multiple mandates in this space, in that jurisdiction, which is how we get to that total of 60. So that is our kickoff. We'll be going into all of these upcoming amendments, the new laws that come online next year over the next 55 minutes with you all. So with that, I will kick it over to Jean to start us off in the Northeast.
Thanks so much, Josh. Nice to be with you all. So we're going to look at the Connecticut sick leave amendments, and you can go to the next slide. So the changes here are significant, and that's probably a little bit of an understatement. It's really almost a brand new law that we're looking at, which is going to go into effect January 1. And we're going to talk about all of these key changes that are listed up here. So I'm just going to jump right into this because this could be an hour-long webinar on its own, and just want to make the most use of it. So if we could go to the next slide. So what you can see here is that what Connecticut has decided to do is to phase this in. And so right now, the Connecticut sick leave law only applies if an employer has 50 or more employees in the state. And then as of January 1st, it's going to apply if you have 25 or more employees in the state. January 1, 26, 11 employees. And then by January 2027, everybody will be covered. And so, in addition to this employee threshold number going down, what we're also seeing is that they have expanded who this applies to. So the prior sick leave law didn't cover certain manufacturers and nonprofits. Those folks are now covered, and there are really very, very limited exemptions. It's really only for certain employers in the construction industry, and then even a smaller subset of those folks who are subject or participate in a multi-employer health plan pursuant to a collective bargaining agreement. So I'm going to imagine that's not most of you on this line. So also self-employed individuals are not covered. And so then we can go to the next slide. And we're looking at, who are the covered employees. And so as you can see from this first column, most employees are gonna be covered. And this is going to apply to both exempt and non-exempt employees. The prior law only covered service workers and specifically exempted anybody who was an exempt employee under the FLSA. And so essentially at this point, almost all employees are going to be covered. The right-hand column does list out the folks that are not going to be covered, and those are seasonal employees, which interestingly is just defined as an employee who works less than 120 days per year. And in figuring that out, you're going to count the days that are actually worked. And it doesn't matter how many hours an employee works in a day. If they work for 1 hour, that day is going to count towards the 120 days. And there's no requirement that seasonal mean that it's the same time every year. It's just anyone who works less than 120 days, which may in fact be some regular part-time employees that you have, is not technically covered by the statute, though I imagine some employers will still extend sick leave to those folks. And again, we have this exception for certain construction workers that aren't going to be covered. And so we can go to the next slide. where we're going to talk about the reasons for use. And so what you'll see is the first three reasons for use are typical of all paid sick leave laws. They're your basic, you have an illness, injury, health condition you need to have taken care of. You need to get a medical diagnosis, care, or treatment, or for preventative medical care. And that's for both the employee and the employee's covered family member. In October of 2023, Connecticut added Mental Health Wellness Day as a covered reason. And you can see the definition here is really, it's broad. Essentially, whenever an employee feels that they need to take the day off for their own emotional or psychological well-being, that's going to be a covered reason. And so, that really expands and essentially allows people to take a day off when they feel like they need it. And then the final one on this page is for employees who are victims of family violence or sexual assault, or are the parent or guardian of a child who is a victim of family violence, and can be used for the reasons that are listed here or other reasons related to domestic violence or sexual assault. And then the next slide looks at the two new reasons that have been added pursuant to the amendments, and these are both under the public health emergency bucket. And, for those of you who do a lot of sick leave in multiple states, these are going to feel very familiar because they're similar to what we see in other places. And, essentially, if there's a public health emergency and the employer's place of business is closed, or a family member's school or place of care is closed, an employee can use sick leave. And then also if it's determined that the employer or the family member poses a risk to the health of others because of exposure to a communicable disease, they can use the time. And that decision can be made either by a health authority, by the employer. The employer could say, we don't want you to come to work because, we're afraid that, you might get other people sick. Or if their healthcare provider recommends that they not come in. Some statutes had only allowed a health authority, but now we're seeing that expanded to employers and healthcare providers as well. And so the next slide just looks at who are the family members for which employees can take time off. And this is one of the areas that has been broadly expanded with the amendment. You can see the list here. It used to just be a child or a spouse. Now it is a spouse, sibling, child, grandparent, grandchild, parent of an employee. And so it's, and all of these terms are also defined broadly. And then if you look at the category at the bottom in green, you're going to see that it also includes an individual related to the employee by blood or affinity whose close association is similar to that of a family relationship. And really, that's kind of a catch-all, which in my mind anyway, kind of expands this to folks being able to take this time to really care for anyone or take anyone to a doctor's appointment. And sometimes I talk to employers and they say, oh, this is going to be crazy. But in reality, people don't take care of other people or take other people to the doctors if typically they don't have this kind of close relationship with them. So even though this feels really broad, I think in practice, we don't see that it has a huge impact on employers. So the next slide is probably the one that I think is most surprising to employers and is where the Connecticut statute really veers quite a bit off the, what we normally see in these paid sick leave laws. So the first thing is in terms of notice. And what the statute essentially says is that employees are not required to give advance notice to use sick leave. And when they say that, they mean it. However, they do say that you can, strongly encourage employees to let you know as soon as practicable. And you can still have reasonable guidelines around when people should notify you that they're not going to be in, but you can't discipline employees if they don't follow the procedure. So I think that this, could be an area where, employers really struggle quite a bit. But I think if you're really clear about what you want people to do, for the most part, people will do it. But I think you're not going to get the kind of notice that you might otherwise have, and you're not going to be able to discipline people if they don't give you the notice. And then the documentation is the other area. So essentially, not even essentially, the law says that you can't require any documentation for covered paid sick leave. And I think all of us thought, well, they can't possibly mean that. Maybe in the, in the FAQs or something, they'll tell us something different. But in fact, it is as simple as that. You cannot require any documentation. If somebody calls in, you can inquire whether they are taking leave for a reason covered by the sick leave law, but that is really about all you can do. And so this is one area when you're looking at having a multi-state sick leave policy where you likely will need to do some sort of carve out for that. So the next slide, we're going to talk about accrual and use of paid sick leave. And so here is where Connecticut now comes back into the mainstream. And so the accrual rate is 1 hour for every 30 hours worked, which is very typical of a lot of statutes. It had been 1 hour for every 40 hours worked. So you will need to adjust your timekeeping systems to account for that. And then just now that exempt employees are covered, you just want to remember that for exempt employees, regardless of the number of hours they work, they're going to be considered to have worked 40 hours a week for purposes of sick leave accrual, unless they're regularly scheduled to work less than that. So if you have a person who's exempt but works 35 hours a week, then you can use 35 hours a week. The accrual cap, again, is on the norm to low end at 40 hours of paid sick leave per year. So that's how much people can accrue and use in a year. And that's regardless of carryover. So, and we'll talk about that on the next slide, but you can only accrue up to 40 hours per year unless you choose to let people accrue more. And then increments of use, you have to allow employees to use sick leave in 1 hour increments. You can always use a smaller increment, 15 minutes, a half an hour, but it can't be more than an hour. And then more just information on use of paid sick leave on the next slide. There is a waiting period. So employees do start accruing paid sick leave from day one, but they can't use it until after the 120th day of employment. And so that's a little longer than I would say most sick leave statutes are. We usually see 90 days, though there are a couple outliers like Connecticut that it's a little higher. And this is another one of those real differences from the old law. The old law, you used to have worked for 680 hours to be eligible, and that requirement is no longer in effect. So you'll need to, again, account for, when do you start allowing people to use this time will be different. So break-in service, this is another area where Connecticut is a little less generous than some other states. So essentially what they say is that if you are, if you leave and then are rehired, your paid sick leave is not going to be reinstated. But if you had worked for the employer for 120 days, you don't have to go through that waiting period again. So you would be able to start using your sick leave as soon as it's accrued. And as is typical of most of these statutes, you cannot require an employee to find a replacement in order to use paid sick leave. And so next we're going to talk about everyone's favorite topics, carryover and front loading. And the nice thing about the Connecticut statute is that they have made it easy and addressed these issues. If you are using an accrual method, there is a 40-hour carryover requirement, which is the same as from the prior law and is, typical of a lot of these statutes. However, if you decide you want to front load, meaning you grant the time on January 1st or whatever date your leave year starts, you can do that. And if you front load the 40 hours and it's available for immediate use, then you don't have to do carryover. And so that is helpful. I know a lot of employers find that system is much easier than having to do the accrual. And then there's just a little bullet here about successor employees or transferred employees. And there are just provisions in the statute that say in those cases where, one company has been bought by another company, but all the employees kind of stay and continue, that their sick leave balances would transfer. And also if an employee transfers kind of internally within the company, that their sick leave would also transfer over. And then in the next slide talks about using other time for paid sick leave compliance. So can you use your vacation, your personal days policy, your PTO policy to comply with the paid sick leave laws? And in Connecticut, like in most states, you can. And here you can see the conditions under which that's the case. It has to be, you can use it for the same purposes. It accrues at the same or a faster rate than you have to under the statute. And then the amount of PTO that you provide, or whatever kind of pay time off you're giving people, vacation, has to be equal to or more generous than the law's requirements. The statute was amended to say that in addition to those things, that employers also have to comply with the paid sick leave documentation requirements. And we're going to talk about them in just a minute. There's a note here at the end that paid sick leave doesn't have to be paid out upon termination. And, that's true regardless of sort of how you are satisfying this. So, if you are using PTO, you don't necessarily have to pay that time out, except if you have a policy that says you will, or if you are subject to a collective bargaining agreement that requires you to pay it out. In those cases, even though sick leave typically doesn't have to be paid out, if it's part of PTO or you're using something else, then you would have to pay it out like you would that time under those policies. And then the next slide just talks very quickly about payment of paid sick leave. And this is not changed from the current law. So you have to pay workers the greater of their normal hourly wage or the minimum wage. And so, and the reason they have that in is, if you can imagine, for tipped workers who maybe don't get paid the minimum wage, the full minimum wage when they're working, they would have to be paid at least that much when they are taking sick time. And then, how you calculate the normal hourly wage is just listed here. So if you are, looking for some guidance on that, we're happy to help. But it's pretty straightforward in Connecticut. And then the next slide, we're going to talk about some compliance requirements. So the Connecticut amendments do have both posting and notice requirements. So you need to display a poster in English and Spanish. If you have remote workers, you also need to either email the poster to those workers or make it available on your company intranet or some other digital platform that folks know about and is easily accessible to them. And then you also have to provide written notice by January 1st to all your current employees and then upon hire. And the Connecticut DOL has published a sample notice that we have a link to at the end of this section. And so in addition to the notice and posting, there are record keeping and balance notification requirements. So employers have to track and keep record of the hours that employees are working. And then they also need to keep track of the amount of sick leave that's accrued and used for each employee. It had seemed initially that this was going to have to be on the pay stub, but that's kind of been walked back. And so it appears at this point that employers just need to keep these records and they must allow the Connecticut Department of Labor or employees access to the records. One nuance of Connecticut law is that if employers are maintaining these balances electronically, that's okay, but you have to get the employee's consent to do that. And that's also true of electronic pay statements. But even if you have consent for the electronic pay statements, the DOL is saying you should still get additional consent for this information to be included. So that is kind of a pain point for employers. And then the access to that just has to be convenient, secure, and private, and you have to ensure that people can print the information out. Records have to be retained for 3 years, and violations of these record-keeping requirements subject you to civil penalties of not more than $100 per violation. So if you have a big workforce, you could see that not complying with this could add up in terms of fines pretty quickly. And then lastly, I just wanted to talk through a couple of transition issues, moving from, what is the current law to what it's going to look like. And so the Connecticut DOL has put out some information, and they address the waiting period. So essentially, if you have employees who have been employed for 120 days, as of January 1, they're going to be immediately able to use their paid sick leave as it accrues. They don't have to do the 120-day waiting period. If they haven't reached the 120-day mark by January 1, they won't be able to use the time until after they work a solid 120 days. So 120 days from January 1, unless you choose to waive that requirement or make it shorter for those folks. And then if you were previously covered by the law, you do have to allow employees to carry over up to 40 hours, which was the rule under the old law, is the rule under the new law. And then they carry over and then just begin accruing at the 1 hour for every 30 starting January 1. For employers that have a benefit year that is different from a calendar year, so January 1 doesn't reset everything, what the DOL has said is that you have to start allowing employees to begin accruing 1 hour for every 30 hours worked on January 1st. And that's even if you front loaded 40 hours at the beginning of the most recent benefit year. And essentially the DOL is saying, the law has been significantly changed in numerous ways. And so, you're going to have to follow the new law in this regard. And you can switch to a front loading method at the beginning of the next benefit year. So if your benefit year starts in June, you have to allow people to accrue time at 1 hour for every 30 until June. And then if you wanted to front load, you could front load 40 hours at that point. So that is a little confusing, I feel like. So if there are questions about that, we're happy to try to help folks. And then the final slide for Connecticut just gives you some resources. So the DOL has a page that has a lot of these links on it. But I wanted to, the sample notice, the poster, some frequently answered questions are linked here for people who want some more information. And then I'm just going to quickly turn to Massachusetts. Luckily, Massachusetts had a just very small change to their statute. And you can see on the next slide that they just added another reason for use. So the covered reasons have now been expanded to include a pregnancy loss, unsuccessful assisted reproduction, or a failed adoption or surrogacy. And the sick time is available both for the person, experiencing that, or if their spouse is experiencing any of these things. And you can just see a practice point here where we are seeing more and more employers from a benchmarking perspective include reproductive loss as a covered reason, generally in their bereavement leave policies. And, for those of you who have employees in Illinois and California, you're probably familiar with that because it's included in the Illinois and California bereavement leave laws. Massachusetts is the first state to include this as a specific reason for use of sick leave. Kind of unusual because a lot of these reasons probably would have been covered anyway under other reasons for use, but in any event, this is the way Massachusetts has decided to address the issue. And that is it for me, and I believe I'm handing it over to Kathy.
Thanks, Jean. And look, we're going to move pretty quickly through California. Next slide. We'll lay out some of the key changes that are going into effect there. I'm sure a lot of people on this meeting are familiar with California's Victims of Domestic Violence, Sexual Assault, or Stalking Law. And really what we're going to be talking about today are changes that impact that law and also how that works with the paid sick leave law. Those changes are going to be going into effect on January 1st, so coming up pretty quick. And on this slide, we go over just a few of the key ways that that things are going to be changing. One point to just call out here that's not addressed on some of the later slides is preventative care for outdoor workers. This is a little bit more of a nuanced area and definitely industry specific, but it is worth noting that for agricultural employees working outside, the ability to use PSL for preventative reasons has been made explicitly clear to include avoiding smoke, heat, or flooding conditions as noted here. So if that impacts your employees or your industry, definitely something to pay attention to. And we'll go ahead to the next slide and get into some of these other changes there. So as I said, really the primary changes in California is this recasting and reframing of the victims of domestic violence, sexual assault, or stalking. It's being broadened in a couple of different ways. One, it's no longer going to be limited to this idea of domestic violence, sexual assault, or stalking. We're now going to be talking more about qualifying acts of violence, and we'll get into what that definition means in a little bit here. We also now are expanding beyond just when an employee is a victim into when an employee or their family member is a victim. So that's definitely a broadening of the law. And you can see on the slide here that in addition to those expansions, we also now they've made it clear that employees can use their sick time for time off for jury duty or time off to appear in court as a witness, as well as for these victim-related reasons. So definitely something to pay attention to, not just for your paid sick leave policies, but your policies regarding that type of jury service or witness appearances in court. Next slide, please. And one thing I didn't mention from that prior slide as well is that the victim status and family members as victims also now qualifies employees for reasonable accommodations. So again, something to keep in mind with your reasonable accommodation practices, and primarily that's to ensure safety of the employee while they are at work. So taking a look at the reasons for leave, again, we talked about already that this definition of what qualifies you for this type of safe time leave is expanding. This slide really gets into what that means depending on your employee headcount. So for all employers, regardless of size, employees need to be able to obtain any relief when they've been a victim or their family member has been a victim of that type of crime. But for less than 25 employees, it's limited to the employee or their child. For more than 25 employees, we have these additional categories of relief. And you'll see there, we've got a chart that really highlights all of these 5 categories that are really specific to when an employee needs time to aid a family member with something related to the family member's status as a victim. So this is a completely new sphere of relief for California, where again, the family member wasn't really contemplated in this type of safe time previously. The other bullet points that come below that, those are not limited to family members. That's when either the victim or their family member when either the employee or their family member has been a victim. So again, still several additional categories of relief there. Definitely some overlap with what existed under the law previously, but whereas I think we had about 5 categories before, we're now up to 10. So it's a big expansion and definitely something to pay attention to in both your policies and your practices of how you're affording that time off. Next slide, please. All right, and I said we'd get to the definitions. These are obviously very critical to understanding when the leave needs to be provided, is how the law defines what is a qualifying act of violence. So it is inclusive of domestic violence, sexual assault, and stalking, but it's also conduct or a pattern of conduct that results in bodily injury or death to another individual, or this idea of brandishing or using a weapon or a firearm against another individual, or making some type of actual or perceived threat to use force against someone to cause a physical injury or death. The family member definition that is used here should be familiar to you. It's essentially analogous to the family member definition that we already use in sick leave purposes. And again, we've got that designated person requirement, which is now pretty common in various California laws, and can here also be limited to one designated person per 12-month period. Again, that's pretty consistent with what we have, what we've seen already under the sick leave law in the state. Next slide, please. So the amount of leave that's available for this type of victim status or family member victim status is worth noting. First and foremost, this time off is going to run concurrently with any CFRA or FMLA leave. And if there isn't any paid sick leave to be used for these safe time purposes, the leave is unpaid. But they can use their sick time and they can use their vacation time. I'm not going to read through the different durations of leave in detail, but you can see up here that the general standard is 12 weeks, and then there are a few situations in which that's limited to 10 days or limited further to 5 days. Next slide, please. All right, so now we're going to move over to a bit of a meatier topic than California. I know California is normally a problem child, but today they get off a little easier. We're going to talk about Michigan, and there have been some big changes in Michigan that we've kind of seen coming for the past 6 or so months. You can go ahead to the next slide. Back in July of this year, the Michigan Supreme Court issued a long-awaited decision and held that the current paid sick leave law in the state, the Paid Medical Leave Act, is unconstitutional and reinstated the state's Earned Sick Time Act of 2018. This is a long time coming. There had been about 6 years of uncertainty as to the status of paid sick leave in the state. So it's good that we've got some concrete direction, although it does mean a lot of changes for employers in who is eligible for sick time and how accrual and carryover and all of the different terms of that sick time work. On this slide here, you see just some of the highlights of what we're going to be covering in the coming slides. And important to note that the effective date for this is February 21st. So it is coming up pretty quickly, and it's definitely worth looking at your policies. Next slide, please. Okay, so first and foremost, we've got a big expansion of employee eligibility. I'm not going to spend a lot of time talking about what the current law allows, but you can see it there on the slide. Really, the important takeaway here is that under the ESTA, an employee is a pretty broad definition. It's any individual who is engaged in services to an employer in the business of the employer. We are no longer seeing hours per week limitations. We're no longer seeing primary work location limitations. And this also applies to exempt and non-exempt employees as well. And the only true limitation is if you're employed by the US government. With respect to employees who are covered by a CBA, if the CBA is in effect on the effective date of this law, then the law will only apply beginning on the expiration date of the CBA. So that's something also to keep in mind. You're going to want to take a look at the terms of your CBA, when it expires, and what protections are extended to employees under there in this category. Next slide, please. Okay, so similar to the employee definition expanding, the definition of an employer is also expanding. We're no longer limited to 50 plus employees in the state. Essentially, any employer in the state is going to have to be providing some type of sick leave under the ESTA as soon as they employ at least one individual in the state. Now, there are these reduced obligations if you're a small business, but small business is viewed pretty stringently as less than 10 employees during a given week. The minute that you have more than 10 employees in any 20 plus work weeks that are not necessarily consecutive work weeks, you don't qualify as a small business under this law. And for the employee headcount, it's important to note that that includes factoring in your temporary employees that you might have through staffing agencies and the like. Next slide, please. Okay, so getting to what I'm sure everyone was very curious about, how the accrual rate, usage cap, and accrual cap are all changing. So again, we've now got, as we've seen in some of the other laws that have changed nationwide, here we've got PSL accruing at a faster rate than it did previously. 1 hour for every 30 hours work compared to every 35. And a very important factor here, there is no cap on accrual. So previously you could accrue up to 40 hours, but now employees need to be able to accrue as much as they can based on their hours of work with that accrual rate. So that's a significant change. And the one limitation is that they can be capped at using 72 hours per year. This is again an increase from the 40 hours previously. I've noted on this slide where the exception comes into play if you are a small business. So that's something worth noting. But important, we've talked a lot already about where you need to look at what your policies are providing and in all the various states implicated in this webinar. This is something where also check what your payroll systems are set up to do and make sure that they're not stopping accrual at 40 hours. Next slide, please. Okay, so again, big changes in the world of carryover and front loading. We go from having a cap of 40 hours being carried over per year to no express cap stated in the law. And similarly, we also have the law being silent on front loading. Now, the FAQs that have been published already have already confirmed that front loading is not prohibited as long as it complies with the accrual, use, carryover, and other provisions of the law. This is going to be pretty similar to what you see in San Francisco or Washington State. And that language is pretty clear. So if you're front loading, keep in mind that doesn't necessarily, it doesn't dispose of all of these other requirements of the law, and you would still need to provide for carryover or accrual, carryover and accrual under the law. Next slide, please. The reasons for use are pretty consistent from the current law to the ESTA. We do have one new reason for use that's noted there, and this is something we see in a couple of other jurisdictions as well for meetings at your child's school or place of care related to health or disability. So not a massive change there, but again, something to make sure that you're extending employees the ability to use the time for that additional use. Next slide, please. And we do have some expansion of family member coverage. The definition of what was covered under the current law and what's covered under the ESTA is on the slide for you there. But importantly, the ESTA now also includes domestic partners and any other individual related by blood or affinity who's equivalent to a family relationship. Again, both of those are categories of family members that we see in a lot of most paid sick leave laws nationwide. So Michigan really just coming in line with some of those other laws. Next slide, please. This is going to be an important one. So the increments of use, there's a change here. We go from a 1 hour increment to the smaller of an hourly increment, or the smallest increment that your payroll system will allow. And the FAQs give the example of if you've got a 1/10 or 6 minutes of an hour for tracking attendance or absences, then that would be the minimum increment of use allowed for paid sick leave. So something, again, to check with your payroll systems, what's permissible there, and certainly a change from the 1 hour standard that was previously in place. Where we saw in the jurisdictions that Jean was speaking about earlier is some changes in notice and documentation that were maybe more restrictive for employers. Here, Michigan's gone the opposite way. We've got a little bit more leeway where you can require 7 days notice for foreseeable absences. But on the documentation piece, it's now limited to no more than 3 consecutive days before you can request that documentation. And I'm going to go really quickly over the next 2 slides because we are running short on time. So next slide, please. This is going to be very similar to what we've got in other jurisdictions as well, where you can use your non-sick PTO for compliance, provided that you're providing leave in the same amounts, same reasons, under the same conditions as under the ESTA, and that it's accruing at the same or a faster rate. Next slide, please. The payment of paid sick leave, that rate of pay is not materially changing other than you can see there in bold, whereas before it was either their normal hourly wage or base wage or the applicable minimum wage here. wage rate. Here, the ESTA is confirming it has to be the greater of those two. The FAQs do use the terminology regular rate of pay, and it remains to be seen whether that terminology is a departure from the statute's normal hourly wage standard or not. But hopefully more to come on that prior to the effective date for the law. Next slide, please. All right, just a few final notes here to wrap things up for Michigan. So these are additional compliance requirements and provisions. There is a poster that is already available on the department website. We recommend you check that out and get that posted. And you do also need to provide written notice of the law. There's a 3-year record keeping requirement, which is an expansion from the prior 1 year. And there is a new requirement to reinstate paid sick leave balances if an employee is rehired within 6 months of separation. So again, make sure your policies are up to date on that point. And you can see here some new enforcement penalty, private right of action information. All of this is new from the prior year. So definitely a little bit more stringent in terms of enforcement than under the current law. And with that, I am going to kick it over to Renata to take us through Minnesota.
Thanks so much, Kathy. Hello, everyone. So the Minnesota Earned Sick and Safe Time Act just went into effect about a year ago in January of 2024, and the state has already amended this law. The majority of these changes, which we'll take a look at on the next 2 slides, took effect in May of 2024. So as an initial matter, the amendments changed the definition of employee, most notably clarifying that the law applies to any employee who is anticipated to work at least 80 hours per year in Minnesota rather than employees who actually work 80 hours. This is somewhat significant because although there isn't technically a usage waiting period under the law, under the prior version of the law, an employee arguably would not have been eligible to use their time until they actually met that 80 hours worked in the year. Now they must be permitted to use it as it accrues. The new definition of employee also includes certain types of workers, such as on-call firefighters and ambulance personnel, among others. The May 2024 amendments added bereavement leave as a covered reason for use. Specifically, employees can use their sick leave if they need to make arrangements for or attend a funeral or memorial service or address financial or legal matters that arise after the death of a family member. The amendments also restrict the use of paid sick leave for weather-related events for certain types of employees. And they clarify the minimum increment of use. Previously, the law required employers to allow employees to use their sick leave in the same increment that the employer's payroll system uses to track other types of time, must be less than 4 hours. So that meant that technically some employees would be able to use their sick leave in increments as small as 1 minute. Moving forward, the amendments clarified that employers are not required to allow employees to use their sick leave in increments of less than 15 minutes. That said, from a practical perspective, if you are a multi-state employer using a single sick leave policy to comply with multiple laws, you may want to give it some thought before transitioning to a 15-minute minimum, because a lot of the other sick leave laws that are still in place in other locations do have that more generous standard. Moving on to the next slide, we'll take a quick look at rate of pay first. The amendments clarify that the rate of pay an employee is entitled to is the base rate of pay. For employees with multiple hourly rates, that's the rate they would have received at the time the leave is taken. For salaried employees, it's of course a salary continuation. And for employees who are paid on some other basis, it's minimum wage. In terms of balance notification, under the original law, employers were required to print employees' paid sick leave balance information on their pay stubs. The amendments clarify that using an electronic system or some other reasonable system for notifying employees is also allowable. However, if you're going to do that, you need to provide access to an employer-owned computer during regular working hours, and it must have the ability for employees to view and print their balances. So in practice, if you're going to make that transition, you need to give some thought about your workforce and ensure that even employees who aren't necessarily normally using computers to perform their jobs have access to this equipment, and also consider remote workers setups and, whether they're truly able, to print from a home office on their laptops and that sort of thing. In terms of documentation, the amendments clarified that the more than 3 days standard means consecutively scheduled work days, and also added that if an employee is using safe time and they're not able to obtain documentation without within a reasonable time or without added expense, that you have to accept the employee's own written statement. On the next slide, we'll talk about the amendment that is going to take effect on January 1st. The amended law says that all paid time off and other paid leave made available to an employee by an employer in excess of the minimum amount required under the law for absences from work due to personal illness or injury must meet or exceed the minimum standards and requirements provided in the law. And this excludes short-term disability, long-term disability, and other salary continuation benefits. Now, this is the first paid sick leave law to include this type of provision, and it really seems pretty radical. In practice, using paid time off, a universal paid time off policy for paid sick leave compliance can be complicated. And we've done webinars on that in the past, and we'll probably do one again next year. On its face, this really further complicates the topic because it reads as though if an employer provides a universal PTO policy or other type of paid leave and the employee chooses to, use that for anything covered under the Minnesota ESST law, which, as a reminder, would include anything from the employee's own illness or injury, caring for a family member, bereavement leave, weather closures, and so on and so forth, that you have to treat that time as protected, meaning, the minimum increments of use, and you can't require manager approval, and so on and so forth. And so, unfortunately, we really don't have much guidance on the impact of this. There is an example on the Minnesota ESST website, which says if an employee receives 50 hours of PTO in addition to the minimum requirement of 48 ESST hours per year, then the employer must follow the ESST requirements about notice, documentation, anti-retaliation, and so on and so forth. Now, the guidance seems to be aimed predominantly at PTO, but it's really unclear at this point and leaves open, the question whether other types of leave might be covered by this. There is at least legal interpretation that, beyond STD and LTD and salary continuation that we know are carved out, that other types of leave may be impacted. So this is really going to require some specific analysis of your policies and your particular risk tolerance as an employer. Shifting to the 2024 paid sick leave ballot initiatives on the next slide, and even moving forward to the next slide after this, the voters in Alaska, Missouri, and Nebraska have turned out, they've made it known that they support paid sick leave mandates. And as Josh mentioned at the introduction to this presentation today, this is a pretty significant development because these three states have traditionally been Republican, whereas by contrast, the majority of the states where we typically see paid sick leave laws have been blue states or maybe purple, swing states, so to speak. So this might be indicative of a wave of sick leave laws coming in other red states. And at this point, we really only have the information that's, in the laws on the books, but perhaps we'll see some more guidance and rules coming forth over the next several months before these laws go into effect. All of these will be mid-year laws. Before we jump into the substantive topics, I did want to mention that at least one of these, the Missouri law, is under a legal challenge right now. So there is a lawsuit pending, depending on how that all shakes out. Some dates may change and things, but for the purposes of this presentation today, we're assuming that things are moving forward on schedule. So Missouri will be the first one taking effect in May, followed by Alaska in July, and then Nebraska in October. Generally, these laws have pretty broad employer coverage and employee eligibility standards, with some exceptions. Can't really get into those right now with our time constraints, but we'll move on to the next slide. Under all of these laws, employees will accrue 1 hour of paid sick leave for every 30 hours worked. There's no cap under the Missouri law. 56 hours is sort of that baseline for Alaska and Nebraska. It's unclear at this point how front loading might work, but there is a 56-hour usage cap, smaller for small employers, under each of these laws regardless. And that's kind of a significant development because if you think about about the paid sick leave baseline standards that we've had in other laws and are typically blue states like California and Massachusetts and Oregon and New Jersey and Connecticut, they're typically 40 hours. So now we have these red states that are actually providing a sick leave benefit that's more generous than some of the blue states. So we'll see, moving forward, if that might be indicative of trends in the future. Moving on to the next slide, you'll see a lot of parallels in these laws in terms of small increments of use, no usage waiting period, and an obligation to reinstate balances. Moving on to the next slides, and we can fly through these pretty quickly. The reasons for use in Alaska are pretty standard 3. In Missouri, the next slide also pretty standard, but adding some public health emergency related reasons. And finally, on the next slide, Nebraska, same thing. The last slide on these laws is our family members, and there are a lot of parallels to these, a couple of additional reasons in some of the states, but there's a lot of information on this slide, and I want to make sure I leave Josh some time, so I'm going to pass the mic over to him to talk to us about New York.
Thank you, Renata. Hi again, everyone. So to wrap up today's discussion, we're going to spend a few minutes on New York paid prenatal leave. I'll say with about 5 minutes left in the presentation, happy to stay a little bit after the top of the hour for folks to kind of get through this part of the discussion, as well as to go over a couple of questions that folks have been sending over. We've been sending our responses along as best we could, so please take a look at those. If you send your questions, we'll do our best to get to as many of them as possible. New York paid prenatal leave, next slide. So this is a novel type of law. It is a standalone paid prenatal leave mandate, one that, while paid prenatal leave as an absence, is covered under some paid family medical leave laws, not the focus of today's webinar. This is the first standalone, in addition to other leave, paid prenatal leave mandate in the country. Starts in 2 weeks from today on January 1st. There are new FAQs that came out earlier this month. No regs yet. We expect them. We don't know when. The New York State paid sick leave regs, which, as a reminder, that bottom bullet point, you can see paid prenatal leave is part of New York paid sick leave law, right, the same section of New York labor law. The New York State regs came out several months after the law went into effect. So it's very possible that a similar trajectory will happen here with paid prenatal leave. There's also a new website. It has an employer page, an employee page. So take a look at it if you have not already seen it. Next slide, please. Some of the initial details. So broad coverage per this new website, right, requires all private sector employers in the state to provide their employees with paid prenatal leave. Eligibility, similarly broad. All employees working in the private sector are covered, includes full and part-time workers. What are they entitled to? They're entitled to 20 hours of paid prenatal leave during any 52 calendar week period. This does not accrue. It is available for them, similar to, say, how voting leave or jury duty leave or bone marrow, organ donation, blood donation leave is available for the worker kind of when they need it, up to a certain amount, in a given time period. Think of paid prenatal leave in that context, at least as far as, this 20-hour sort of amount of time. So no accrual. How does the benefit year get measured? Well, that again is somewhat of a gray area under this statute. The statute gave us what we thought was clarity during any 52 calendar week period. However, the FAQs added a bit of a twist to that by saying it is really, if you're familiar with the FMLA definition of the 12-month period, one of the options there is sort of the rolling look forward period. This very much feels like that, right? The first time the worker uses the paid prenatal leave for a covered event starts their 52-week clock. So that is the guidance that the FAQs have provided, again, in seemingly conflict with the statutory standard. Next slide, please. So when we're thinking about what absences are covered, we've gotten good guidance from the FAQs and the law itself, right? That the time can be taken for healthcare services received by the worker during their pregnancy or related to such pregnancy. That includes physical exams, medical procedures, monitoring and testing, discussions with a healthcare provider. The FAQs clarify that fertility treatment or care appointments, including in vitro fertilization, is included. So is end of pregnancy care appointments. What is not included are postnatal, postpartum purposes, as well as absences by a spouse or a partner or other support person attending the prenatal appointment with that eligible employee. Next slide, please. When we're thinking about how this benefit coordinates with other leaves and time off, this is a really important point. All right, the statute says that the 20 hours are in addition to the paid sick leave provided under New York Labor Law 196. Now, that is 56 hours of paid sick leave. That's the usage threshold of the New York paid sick leave law. But now we have these FAQs that talk about the 20 hours being in addition to all other existing leave policies, whether that's statutory, whether that's employer provided. It is a separate benefit, and it is in addition to all of those. So that is a unique wrinkle from these FAQs. Again, another example of the FAQs potentially going beyond where the law sort of lands, but something that employers should really keep in mind as they're administering this benefit in a few weeks, because it seems to be the position of the state that this time off is above and beyond all other leaves, time offs that the company provides. The employer cannot require the worker to choose one type of leave over another or exhaust some other leave before using paid prenatal leave. Next slide, please. All right, rapid fire. There is no carryover, no payout at separation, no balance notification requirement. You can't retaliate. That should be a no-brainer. It seems very highly probable that there is a written policy requirement. I would give it a 98, 99% likelihood at this current time, based on the way that New York State labor law is worded and how paid prenatal leave is part of the state paid sick leave law. The rate of pay is the regular rate. You can see the increments of use are down to the hour. And documentation, while still a bit of a gray area, it suggests from the FAQs that employers cannot require documentation from workers based on the language on the slide there. So next slide, please. So we have a quick PTO outlook for you, and go one more. You'll see many of the laws we spoke about are listed on this slide today. So lots of activity in the last 6 months. Federally, it's everybody's kind of guess at this point what might happen at the federal level. I will say that paid family leave is a higher priority than paid sick leave. So if there will be some activity federally, it is more likely that it will be on the paid family leave side than on the paid sick leave side. States to pay attention to: Delaware, they have a paid family medical leave program starting in 2026. Seems possible that they could get on this list. Virginia as well, they have a paid sick leave law, but only for certain home health care workers. We could see that expand to private employers. Pennsylvania with its 3 local paid sick leave laws. Hawaii with its statutory disability insurance law. All are at the top of our watch list, as is maybe every other state. Based on what Renata said a few seconds ago during the ballot initiative part of this discussion, the fact that we now have traditionally red states in Alaska, Missouri, and Nebraska joining this mix next year opens this potential can of worms that the entire country now seems realistic, right, and within grasp with having a paid sick leave law. It certainly seems reasonable that 2 years from now, 3 years from now, at least half of the states in the country will have some type of paid sick leave or PTO mandate on the books. And that, again, doesn't count the many laws that just keep amending and tinkering with their programs, as you can see on this slide. So keep all that in mind. The other big thing to pay attention to is whether New York City decides to pull a Chicago and add a PTO personal time component to their paid sick leave obligations sometime in 2025. Next slide, please. All right, here is the CLE code for folks. You can scan the QR code here. The code is SS as in Seyfarth Shaw 1223. Again, SS as in Seyfarth Shaw 1223. All right, one more slide. So we have a bunch of resources available for folks. I sent this in response to one of the questions. Next slide, please. We have a premium survey that is available by subscription for interested clients. You can reach out to paidleave@seyfarth.com for more information. Also, please sign up for our mailing list. Our If Pain, Yes Gain paid sick leave article series is up to part 128, 9, 30, something like that. Tons of great information there for you. As we roll out this information, you'll get it. Next slide, please. This webinar series every one of these now 15 parts are available online. The slide decks are there. Apparently, they are generally posted to YouTube, so you can find us and hear more about us if you're looking for some way to pass the time over the next few weeks. And we have a podcast called Take It or Leave It that I have the pleasure of hosting that covers all things leaves and absence management, accommodations. We just rolled out episode 37 of that podcast earlier this week. Okie doke. Next slide, please. So I said we would hang on for just a couple of minutes here. We're a few minutes over, but for anybody who wants to kind of stick with us, see what sort of questions have come in that we haven't had a chance to get to yet. So let's see. There are a few questions about unlimited PTO and how it fits in the sick leave space. I'll just sort of say, the unlimited PTO is very attractive on its face. We spend a lot of time working with our clients, however, to navigate the contours and challenges of using it for paid sick leave compliance. There are a lot of them. It also poses, challenges and potential risks in the FMLA and ADA spaces as well, other leaves of absence. So it's something that needs to be navigated carefully from a strict sick leave perspective. Using any type of PTO for compliance is generally doable, but you have to provide the right amount of time, make it available for the right reasons, and under the same conditions as paid sick leave. And that's not sort of a hard and fast rule in every one of the 60 locations that have this type of law, but it is generally the rule in most of these locations. I see a paid prenatal leave question that came in from Cheryl. The question here is, if we already provide generous sick leave of 100 hours, are we in compliance with the 20 hours of paid prenatal leave? It's a really good question. The short answer is I don't believe so. Again, these FAQs have come out and sort of no black and white to it have said this benefit is above and beyond all other leaves and time off that laws provide and that the employer provides. So that feels at this moment like the safest, more conservative route for employers to go. And there are a lot of practical and other legal considerations that come up in that point as well. So I am happy, if folks want to reach out to see if there's a way we can kind of communicate offline about that. But know that you're not the only one with that question, and it is messy, it is complicated. Okie doke. Let's see. Do a couple more. There were a bunch of Connecticut questions that came in early on. I'll jump to one of those. Gene, there was a question about sort of notice and posting for the amended Connecticut law, and I know that's coming online again in just 2 weeks from today, and that the prototype notice, they couldn't call it a template notice, they had to call it a prototype notice, which was fun for everybody. If you like patent law like I do, you'd enjoy the prototype naming. So can you maybe just spend a second talking to folks about sort of that notice posting obligations under the amended Connecticut law?
Yeah, so the Connecticut law requires both of those things. So there is a, typical posting requirement. You need to put this poster up in your facility or office. And as I mentioned, also need to send it to remote employees or make it available on your intranet or, some other digital platform. And then there is a separate individual notice requirement, meaning you have to send this notice. It's different from the poster to employees, and has to go to all your employees in Connecticut as of January 1st, if you're covered by the statute. One of the things that the DOL did say is that, if you have less than 25 employees in Connecticut, you can wait until you become subject to the statute before you send the notice. So you're not sending the notice to people who aren't actually eligible for the time off. But you do have to send this individual notice, and both the poster and the notice are linked on that last slide in the Connecticut section of the deck that you'll all be receiving.
Great. Thank you, Gene. All right. So there's a question on California, Kathy, that came in from Kelly a minute ago, talking about just California localities that are there any that have sort of a higher accrual carryover or balance cap than the state law. So I know you and I talk California all the time. So if you want to just weigh in on that for a second for folks.
Sure, yeah. So there are a lot of California, a whole patchwork of California laws in addition to the state law. We've got everything from San Francisco, Berkeley, down to Santa Monica and West Hollywood. And several of them align with the state requirement, and several have different requirements and more generous requirements in one way or another. San Francisco, Berkeley, Oakland definitely have some unique and differing requirements that require employers in those locations to be more generous than than the state requires, including some restrictions regarding front loading, no caps on usage, and similar kind of terms that you would want to take a close look at there. West Hollywood is another location that's got a definitely more generous requirements than the state. They break theirs out into compensated time off and uncompensated time off, and it's larger buckets and different accrual rates and a special 80 hours of uncompensated time for sick leave. So it's a complicated patchwork, even in the locations where it aligns with the state in terms of accrual cap and usage cap and all of those requirements. There might also be different reasons for use. Or different covered family members. We see that in Los Angeles and San Diego. So depending on where you're located, it's definitely worth checking out what different localities you might want to comply with, and we can certainly weigh in and advise on that on a case-by-case basis.
Great. Thank you, Kathy. All right, everybody. I'll say just to the last Connecticut question that came in, and Gene, let me know if I put my foot in this, if I misstep here. But I think that the question is, did they have to send the specific notice provided by Connecticut, or can the company kind of create one with the necessary info? From my perspective, right? I mean, the notice has, and this is sort of a shout out for all you folks that are still with us, and thank you everybody who stuck with us for this. This is great. Some of these laws, their notices and posters do have customization components to them. It's important to keep that in mind. A lot of poster services, which are wonderful at sort of a high level, don't, tend to overlook that point. So keep that in mind, right? This Connecticut law, this notice does have customization to it. So as long as that information is the information in the notice is contained, right, and communicated to workers, existing folks, and then new hires, right, you can sort of create your own, I think, but it tends not to be the recommended approach, right? Because if the state has something that they've released as a model or a template, or in this case, prototype, it is sort of the safest route to kind of use that. Um, Gene, anything to add on that point?
No, I think that's exactly right.
Wonderful. Okie doke. Thank you so much, everyone, again, for joining us, for sticking with us, a little bit of extra overtime here. We hope this was valuable for you all. Clearly, there is a lot going on in the paid sick leave space. The volatility and influx status has been that way for many, many years at this point. The four of us and our very deep bench of leave counselors deal with these laws all day, every day, nationwide, across the country, for all sized employers, all industries. If you have questions, please do reach out. Otherwise, we will wish you all a very happy holidays, happy new year, and we will see you all in 2025.